Have you ever wondered how two people locked in a bitter dispute can sit across a table and come out with a solution that works for both of them? Or what happens when businesses or individuals want to avoid a courtroom drama but still need a resolution? Welcome to the world of mediation, arbitration, and conciliation, the hidden gems of dispute resolution under Indian law. Imagine this. Two close friends, Arjun and Karan, started a thriving tech business together. Everything goes smoothly until a disagreement over revenue sharing shakes their bond. Emotions run high. It seems like the only way forward is a courtroom battle. What if there's a way to resolve their disputes while preserving their relationship? That's where alternative dispute resolution or ADR methods such as mediation, arbitration, and conciliation step in. Let's break it down and start with mediation. What is mediation? Mediation is like having a referee who doesn't take sides. Instead, the mediator helps both parties communicate effectively and find a mutually acceptable solution. The best part is entirely voluntary and keeps the doors open for relationships to mend. A great example is the landmark case of Afcons Infrastructure Limited versus Cherian Varki Constructions Company Private Limited. In this case, the Supreme Court of India strongly endorsed mediation as a preferred mode of dispute resolution, especially in commercial cases. It showed how mediation can save time, money, and emotional stress compared to litigation. Also, in the case of Punjab National Bank versus Lakshmi Chand Rai and others, the High Court highlighted the importance of utilizing mediation as a preferred method for dispute resolution. Here's the beauty of mediation, it's confidential. Unlike court cases where your dirty laundry can become public, mediation ensures your dispute stays private. And since the parties themselves agree on the solution, compliance is often smoother. What is arbitration? Now, let's talk about arbitration. Think of arbitration as a private courtroom, but with a lot less drama and quicker results. Here, an arbitrator who acts like a judge listens to both sides and delivers a binding decision. This method is especially popular in commercial contracts because it's efficient and flexible. A well-known case in this space is Bharat Aluminium Company versus Kaiser Aluminum Technical Services Inc., where the Supreme Court clarified the jurisdictional aspect of arbitration agreements. This case was a game changer for arbitration in India. It made arbitration agreements more robust and enforceable. Under the Arbitration and Conciliation Act of 1996, arbitration is a preferred choice in contracts involving businesses, especially those with international dealings. Unlike traditional litigation, arbitration allows the parties to select an arbitrator with relevant experience. This makes the process much more specialized and effective. Finally, let's discuss conciliation. Conciliation is like mediation's sibling but with a bit more structure. Here, the conciliator plays a more active role by suggesting solutions while maintaining neutrality. The goal is still the same, to reach an amicable settlement. A notable instance of conciliation in action is in labor disputes. The Industrial Disputes Act of 1947 often relies on conciliation officers to mediate between employers and employees to avoid strikes or lockouts. Some landmark cases where conciliation proceedings were invoked are Micro Employees Association versus State of Karnataka, where the case dealt with the powers of conciliation officer under Industrial Disputes Act and the scope of issues that can be brought up during conciliation proceedings. And Western India Match Company Limited versus Western India Match Company Workers Union, where the case dealt with the legal implications of a union not properly representing its members during conciliation proceedings. What makes conciliation unique is the settlement agreement. Once signed, is binding like a court degree. It's faster, less intimidating, and much cheaper than going to court. Why ADR is the future? The Indian legal system, while robust, is infamous for its backlog of cases. Did you know that as of 2025, over 5 crore or 50 million cases are pending in Indian courts? ADR methods like mediation, arbitration, and conciliation provide a much needed relief valve for this overloaded system. In fact, the Supreme Court has repeatedly emphasized the importance of ADR mechanisms. In Salem Advocate Bar Association versus Union of India, the court encouraged mandatory referral of disputes to mediation or conciliation wherever possible. Plus, ADR isn't just for businesses or for big legal disputes. It's equally effective for family conflicts, property disputes, and even community disagreements. And with India's growing focus on ease of doing business, ADR is becoming a cornerstone of commercial contracts. So, what happened to Arjun and Karan, our feuding friends? Instead of dragging the dispute to court, they opted for mediation. A neutral mediator helped them communicate the concerns and arrive at a revenue sharing agreement that worked for both. Not only did they save time and money, but they also preserved their friendship and business partnership. ADR methods like mediation, arbitration, and conciliation aren't just legal tools. They are problem-solving strategies that prioritize relationship and efficiency. Whether you're running a business, resolving a family dispute, or negotiating a deal, understanding these methods can save you from unnecessary stress and expense. If you found this video helpful, make sure to check out our playlist for more informative legal content. Don't forget to like, share, and subscribe to my channel for more videos that simplify Indian law for everyone. Hit the bell icon so you never miss an update. Thank you for watching and see you in the next video. Take care. Bye.